Welcome to Slaughtered Sheep. I'm your host, Matt Daly of MRD Consulting, and you are listening to the Law Dog series in the Slaughtered Sheep podcast. The Law Dog series showcases legal issues, legal planning, legal and regulatory pitfalls, traps, and of course, legal wolves, circling small business owners, posing an ever-present threat to the coffers and bank accounts of small businesses. Today, we have invited onto the show a very experienced and high-level lawyer in the form of Dan Ballantine of Larkin Hoffman law firm based out of Minneapolis, Minnesota. Dan is an MSBA, Certified Labor and Employment Law Specialist, and American Arbitration Association Employment Arbitrator. The law firm of Larkin Hoffman has been representing my various development and consulting companies for over 30 years. Larkin Hoffman has also represented the various ventures of my father, Bob Daly, and my brother, Luke Daly, for the last 3 decades. I've retained half a dozen Larkin Hoffman attorneys in the areas of construction law, employment law, contract law, mergers and acquisitions, and other corporate interests. I can attest to their high level of service and overall knowledge of business law and complex business transactions. I would recommend their firm to any small to medium-sized business and would be confident that they would be well taken care of. We've brought Dan on the Slaughtered Sheep podcast to discuss various wolves circling small businesses regarding employment and labor law and related topics. Today, we aim to cover non-compete agreements, wage and hour, paid and unpaid leave issues, policies and procedures manuals, and other relevant topics that we hope to cover. With that being said, I'd like to introduce to our listening audience of faithful small business sheep, Mr. Dan Ballantine. Dan, welcome to Slaughtered Sheep.
Thanks so much for having me, Matt. It's great to be here.
Thank you for coming, and we look forward to you giving us your wisdom and your insights into what is growing to be an extremely complex world of employment law. I'm hoping that things are going to change with a new administration in, but the vestige of all the other regulations it's a thicket.
We still have the other party in charge in Minnesota at this point. Remains to be seen right now with the legislature, but there's certainly some anti-business measures that have gone into effect in Minnesota that are still in effect.
It varies state by state, and I always say that Minnesota is the closest state to Moscow in the United States. That's definitely a challenge for small business owners here, right?
It can be, yeah.
Anyways, are you ready to fend off some wolves and save some sheep on this podcast?
I'm ready to help as many sheep as I can.
Okay, you got your game face on, Dan. I can see it. We appreciate it.
I'm ready to go.
Before we jump into the employment law topics and issues, I'd like the audience to get to know Dan, the person, the student, and the ever-evolving law practitioner superstar at Larkin Hoffman. So let's spend a few minutes, Dan, talking about your childhood, what it was like growing up as Dan Ballantine, and maybe some telltale signs that you wanted to practice law and what led you to where we are today.
My dad was in the Air Force during the Vietnam War, so I was born on an Air Force base in Michigan, Fort Smith Air Force Base. I think the Clinton administration shut that down, but it was an Air Force base in 1971. But my parents were from Minnesota, and we moved back to Bloomington, Minnesota when I was 4 years old or so. So I grew up in East Bloomington, went to elementary school, public school there, went to Kennedy High School in East Bloomington, and I went to Carleton College in Northfield. And I knew I wanted to be a lawyer before I went to Carleton. The whole concept of going to Carleton is what school is going to be best enable me to get into law school. And Carleton was a very prestigious college, and that was the whole reason why I went there. And in fact, I finished Carleton in 3 years just to get into law school. And when I finished Carleton the summer after my junior year, I finished my degree at Cambridge University in England. And I was still jet lagged when I found out I got into law school. You can imagine law schools are used to 4 years of college, you get a degree. I technically did not have a college degree when I started law school because Carleton only posts their degrees every June. I finished mine in August after my junior year. So long story short, I got waitlisted initially at the University of Minnesota Law School for that reason because I didn't have a college degree yet. Found out 2 weeks before I started law school. Nobody in my family is a lawyer. I like to argue. I like to debate, as my parents always told me. I think I'm a reasonably intelligent person, and it made sense. Why don't I get paid to argue? And so that was what started. Of course, there's much more to practicing law than arguing. But that's what told me I wanted to be a litigator. That's a dichotomy with lawyers. First of all, in law school, Yeah, most people don't understand or don't know what area they want to practice in. They don't know employment law, or do I want to do antitrust law or whatever. But a lot of lawyers think about, do I want to be doing transactional, doing more drafting documents, more office, or do I want to be in court? I always knew I wanted to be in court and preventing people from being slaughtered in court. But of course, I do some of my practices on the front side, I call it litigation prevention too. Since I know litigation, I know what can happen. I think it makes me better suited to advise people and try to take steps to prevent litigation, or at least reduce the damage that can be done from litigation.
And so on that point, that's the purpose of the Slaughtered Sheep podcast, correct?
It is.
Right. We're taking lions like you that are basically strutting back and forth across the courtroom, defending your client's sheep. We don't want our sheep to have to go to court unless, of course, they're an aggrieved party and they need a lion like you representing them. So that's excellent. So talk about your career path as a lawyer. I know you did a stint with Dorsey and Whitney. You're with Larkin now, but you give us a brief overview of that.
Yep. So I graduated from the University of Minnesota Law School in 1995. I immediately started with Dorsey and Whitney in their trial department for about 3 years. My big thing at Dorsey and Whitney is I was involved with the big tobacco litigation at some of the not the younger listeners might remember the big tobacco litigation that the state brought against the tobacco companies in the late 90s. And I got into court on that, which was a feather in my cap for a young litigator. I got a call from a headhunter, basically, that said, hey, you're interested in Larkin Hoffman? And then this was in 1998. I made the move. We are in Minneapolis, but our office is technically in Bloomington, which is where I grew up. So I thought, yeah, absolutely. So I joined Larkin Hoffman in 1998. I have been a litigator in their business litigation group ever since. I started specializing in employment law probably about 2000. I was a general business litigator, and we had an opening in employment law, and I started working with the partners in that group. And it was just supposed to be temporary. Then they decided, we like you, Dan. Why don't you just do employment law permanently? So I did, and I became a partner in 2000, and I've never looked back. I'm a member of our firm's board of directors, and have been for the last 3 or 4 years as well. I'm currently the co-chair of the firm's business litigation department. I was the sole chair about 5-6 years ago. I had a little break in that when I became a board member, but now I'm back doing the co-chairing the department as well. So I've handled a lot of litigation. I would say my practice is probably 50-60% litigation, where we're working on cases, versus the rest, I would call it transactional or consulting. Again, working a lot of times with HR folks, trying to prevent issues. The calls, can I fire this person? Am I going to get sued if I fire this person? What do we do here? How do I put this agreement in place? How can I protect myself on the front end? And I really enjoy doing that a lot too, though I enjoy the litigation piece as well.
So very interesting. So a couple questions for you. As it pertains to the litigation, I'm guessing that the vast majority of your clients per se are companies that are in litigation with either their employees or contractors or whomever, but is that primarily who you're representing, or do you represent individual employees also?
You're correct. The vast majority are companies. I am never on the defense side of a discrimination lawsuit or a sexual harassment lawsuit. I'm always representing companies on those.
Okay, got it.
Non-compete's a big part of my litigation practice as well. And I could be plaintiff or defense on that, because sometimes there's companies suing people on non-compete. So I have been the lion going after the sheep sometimes on non-compete. Sometimes I'm on the defense side, preventing protect sheep. But yeah, to answer your question, it's almost always employers. Every once in a while, I do some work with an executive who's received a separation agreement, help him or her out with that sort of thing. But the vast majority is representing companies.
Got it. Very interesting. Anything else you want to tell us about your career at Larkin Hoffman, or your practice in general, maybe some of the industries that you might specialize in, that your clients are in?
It's a good question. We represent all types of companies. I've done a lot with healthcare companies. We've done a lot with construction companies, doctor groups, every kind of retail. I can't think of an industry that we don't work with. We're a pretty big firm. We have about 85 attorneys, and we've been in practice or been in business for a long time, about 70 years now. So I don't think there's an industry we haven't touched. So.
Yeah. And in the practice that you specialize in, employment law applies to everyone equally per se, whether you're a contractor, a physician clinic, a marketing firm, engineering, whatever. You're going to have employees if you're have any size at all. And as soon as you hire one employee, you're hanging out a big piece of red meat
There's a
for
lot
the
of,
wolves.
correct. And I think you know this, Matt. There's a lot of state laws that basically apply to employers with one or more employees. Some of the federal laws, you need more employees. But yes, there's a lot in Minnesota that you've got to comply with when you hit just one employee.
Yes. And I run into this a lot with my clients. I'll have a client that doesn't have any employees. They have contractors or they're able to do it on their own, but they start to grow. And so I get the phone call. I want to hire a couple of employees. What do I do? We have a checklist. Got to get you set up on payroll. Got to get your tax IDs, blah, blah, blah. But then I start to steer them into the things that we don't do. Workers' comp insurance and all that. We're not insurance brokers, but all of these other regulations with just one employee. So I don't try to talk my clients out of taking that growth step. I've had employees for years. I had 1,000 of them back in the day. So want to get into the topics that we're going to cover. We've got to get in, speaking of lawyers and law and disclaimers. So want to make sure that the audience understands that we are not giving legal advice here. Even though Dan is a lawyer, if you want to hire Dan at any point in time, he'd be happy to give you legal advice. But on this show, we're not giving out legal or tax advice. And I always recommend that any of the listeners retain competent counsel in this area, whether it's Larkin Hoffman and Dan or some other firm that you're currently working with. That's one way that I'm fending off a wolf right there, right? I just dodged a wolf coming straight at me. Let's talk about non-compete agreements. Dan, before we get into it, I just want to talk for a couple minutes. My experience with them, I've signed them as employees. I've had my employees sign them as a business owner. I've also dealt with them when I have been trying to hire employees that make me aware that they have a non-compete agreement. And so I've had experience with them. I understand what these agreements are. The fantastic attorneys at Larkin Hoffman over the years have educated me and enlightened me on these and things like competition radii and all the restrictions that you can put in place and the ones that you can't. But many of our listeners, I'm sure, have heard of these, but may have never signed them or had to draft or negotiate them. So let's just start with the beginning. And what is a non-compete agreement?
Yeah, it's a good question. I'll start with the statute. As many of you know out there, there's a new Minnesota statute that went into effect July 1, 2023. That statute defines a non-competition agreement essentially as any agreement that restricts or prohibits an individual from working in a certain area, working for certain employers, or working in a certain profession. Not to be confused with agreements like non-solicitation agreements, which are things like, you can go to a competitor, you can work for a competitor. We're not prohibiting you from working anywhere, but you can't steal our customers or employees, non-solicitation employees. You can't try to entice our employees away for a period of time. So that's a non-compete, yeah.
So just to clarify, and this is partly for my own edification, do you typically see a non-solicitation in a non-competition agreement? Are they typically go hand in hand, or are they separate agreements, or what?
If they're well drafted, they're both.
Okay, got it.
And then there's confidentiality agreements, which really us lawyers don't think of those as non-competes, but they can still create barriers to somebody finding another job because they can create risks for another employer as well. If you got a strict confidentiality provision, now there's a chance you're going to maybe be sued because that employee may use information that's confidential from their previous employer. The new employer gets sued on that too. But obviously a confidentiality provision doesn't prevent the employee directly from working anywhere. It's another risk potentially that the new employer and the employee has to worry about. But all those are usually in a well-drafted agreement.
So technically, do you refer to these as non-compete or non-competition?
Restrictive covenants is what I say is covering all these things. Non-solicits, confidentiality, non-competes. When I say non-compete, I think of what I said at the first definition. Something that prevents you, an employee, from working somewhere in an area or with certain employers.
So they're typically referred to in layman's terms as non-compete agreements, but the statute itself it references non-competition. Is that technically how it works?
Correct. And just so everybody knows what we're talking about, this is the statute that went into effect July 1, 2023, that essentially prohibits non-compete agreements with employees starting July 1, 2023. That's one first thing I'll tell everybody. They're still enforceable if they're signed before July 1, 2023. It's after that date, but the statute makes clear what's being prohibited prospectively are non-competes with that definition I gave earlier. The statute says non-solicitation and confidentiality provisions are still allowed. So that's the distinction. It's a Minnesota statute.
How many states have this exclusion?
I don't know off the top of my head how many. North Dakota has had basically a bar on non-competes for a long time. Wisconsin has a statute on it that puts some limitations on it, let's just say. I'd be guessing in terms of the number of states that have a complete bar on non-competes. It's not the majority. I would say the majority of states do allow non-competes in some form.
And once again, we're here to talk about the guts of what a non-compete agreement is. However, is this statement true that effective, you said was it July of 2023?
July 1, 2023 is when the statute went into effect.
So effective that date, it would be a complete waste of time and money for a business owner in the state of Minnesota to hire a lawyer to draft a non-compete agreement.
Remember, the statute allows non-solicitation provisions and confidentiality. You could still get an agreement in place. And remember, it's with employees hired on or after July 1, 2023. You can't have just that non-compete with that definition I gave earlier. But you can have the non-solicitation. Stay away from my customers for up to 2 years after you leave. You can say, don't touch my employees. Don't entice them to leave for 2 years. Confidentiality, protect all of your information. All that is still fully in play under the statute. In fact, I think you want a lawyer to make sure that the agreement you draft complies with the statute, but there's all kinds of protections that the statute allows, and make sure you have a lawyer tell you the full breadth of those protections that are still enforceable.
So fair enough, non-solicitation and confidentiality are still in play for business owners,
right?
But just to clarify, in the state of Minnesota, per that statute, you cannot restrict an employee that's hired on or after 7/1 of 2023. You cannot restrict them, in essence, from competing against you.
Correct, because competing or could be including soliciting your customers. So you can prevent that competition. You can't prevent them from working for another competitor or working in a certain profession.
Right across the street.
Correct. The statute also allows non-competes in the connection with the sale of a business. So that's how we're going to make that distinction. If anybody out there has partners, business owners, we're talking employees only. If you've got an employee who's also a business owner, the statute allows that. It's a little unclear. The statute talks about you can have non-competes in connection with, quote unquote, the sale of a business. In my opinion, it's a pretty poorly drafted statute in that regard, because it almost suggests, does the whole business have to be sold to have a non-compete versus you have a buy-sell agreement or just a shareholder agreement, or one shareholder's leaving, you can't have a non-compete with him or her to redeem their shares and leave. But I would argue that, and there's been very little case on this statute since it's been in effect such a short amount of time. I would think that the intent of the statute is, no, if you've got a firm with several owners, who might also be employees, that you could have a non-compete with them in connection when they leave and they redeem their shares or paid for their shares. There's a non-compete. I think you could do that, but it's a little fuzzy in the statute.
So the real issue you're bringing up is, we call it controlling interest, right? So if you have a controlling interest, based on what you're telling me, it sounds like that the non-compete would stick in conjunction with the language in the July 23 statute. In other words, if you sold your controlling interest to another party, that party could hire Dan and say, listen, I want non-compete language in this purchase agreement. I want the former shareholder that had the controlling interest that I bought out, I want him or her to know that they can't compete with me, right? Is that your position on that?
Yeah, the only thing that's gray, the statute explicitly says non-competes are allowed in connection with the sale of a business. And the question is, what does that mean? Is it a whole business or not? But yeah, your hypothetical, Matt, the controlling shareholder controls an interest. I'm only going to buy this business if the controlling shareholder who's leaving now isn't going to set up a shop to compete and take back all of his customers or whatever, and so 2 years or whatever down the road. I believe that would be allowed under the statute. And in fact, a good lawyer would say in that agreement with that controlling shareholder, we're not even going to buy your business. So all this money you're getting for us buying your business is part of the consideration for you agreeing to this non-compete. Make it clear it's tied to the sale of the business.
Very interesting. I deal with that with my client base. I've dealt with it with the companies that I have owned and sold. There's always been a non-compete agreement in play. But the original focus of this was more the business owner and employees, but absolutely in the M&A. This might be more relevant to the listeners, the ones that are considering selling or buying. Of course, the major risk is to the buyer, right? How do you protect? You give somebody a chunk of money up front, you're on the hook for seller financing or whatever. And I had it happen to one of my clients. It was an issue that I brought up and he survived. He was out west. He was a contractor, but the key employee for the firm that he bought, literally the day after the sale, went out, formed a identical business in that market, some crew leaders with him. The guy survived. He called me. I just said, don't do anything right now. Just beat him at his own game, right? Don't go out and hire a lawyer to get in a massive litigation right away. Let's just see where this goes. And that's what he did. He just outmuscled the guy and grew his business and all that. But it was an absolute threat. It was a worry for him. So interesting. Let's talk about what are the key terms in a non-compete. We always start with a term sheet when we have a contract, right? So what are we looking at?
Obviously, the scope of the provision, meaning geographic scope, temporal scope is important. So in Minnesota law for employees, non-competes have generally only been allowed up to 2 years. So in other words, I'm saying non-compete because remember, non-competes that were signed before July 1, 2023 with employees are still enforceable. But it's the same thing with the sale of business. Non-competes still have to be temporally, geographically limited. And let me go back. The main legal tenant, if you will, in Minnesota is non-competes, restrictive covenants, non-solicitation provisions, what have you, are only enforceable to the extent necessary to protect the employer's business. That's in the case law. So any agreement, if you're suing a former employee or a former business owner or whatever, you've got to establish to the court that non-compete, that restrictive covenant is necessary to protect your business. And I'll tell you right now, you're not going to get away with more than 2 years for an employee. They'll be more lenient in the sale connection with the sale of business. 5 years, I know, has been upheld, that kind of thing. Same thing with geographic restrictions. So I've seen worldwide non-competes, which might be okay for certain companies, Coca-Cola, I don't know, big Fortune 50 companies that truly have businesses around the world, maybe. But if you're a ma and pa shop somewhere in the Twin Cities that really all your customers are right here, and let's say you sell widgets and you're going to prevent an employee from selling widgets anywhere in the world, you're going to get laughed at, I think, by almost every judge. That's not legally enforceable. So that's really important that you think about that. What truly is necessary to protect your business and you think you can establish to a court is necessary to protect your business.
So let's talk about that for a second, because I've never had to litigate a non-compete, thank God. I've had good lawyers represent me. But what happens when a judge says, yeah, Mr. ABC contractor, you can't put the whole state of Minnesota in this. This guy has to be able to earn a living just like you. This is way too broad. Is the entire agreement void because of that?
Good question. The answer to Minnesota is no, not necessarily. The doctrine is called the blue pencil doctrine. I love how lawyers come up with all these things. I honestly can't remember what the genesis of why it's called blue pencil. It must be some back 100 years ago, a reference to the type of pen they used or to mark up agreements. I don't know. But the blue pencil doctrine just means if a court finds a restrictive covenant is overbroad, the court does have the ability. They don't have to. They can just simply throw it out. So make my point this way. Let's say the non-compete with an employee is 5 years. And the court says that's just way too broad. The most that really is necessary to protect your business is 1 year. The court has the option of either throwing it out completely, you stretch too far, employer, you're out, or I'm going to enforce it, but I'm going to reduce it to 1 year. And that never goes the other way. The court's never going to say, well, you only did 1 year. I think you could have gotten away with 2 years, so we're going to expand it. It's always just to the employee's benefit. That's not true in every state. There are states that the law is, if the judge finds the non-compete or the restrictive covenants overbroad, they cannot blue pencil it. It's just thrown out. Wisconsin, I think, is that way, for example. But Minnesota does allow it. Then you get down to who's your judge. And it quite often, you talk about the judge, say, look, the person's got to be able to earn a living. There are some judges, we call them right-to-work judges, that when you sue on a non-compete, they're almost never going to enforce it to get the employee fired from the the competitor, for example. They got to eat. And then there's other judges that are much more corporate based and say this employee signed an agreement. Nobody forced the employee to do it. It was done properly. And yeah, sorry, you're going to have to abide by it. A lot of times it comes out to the judge you draw in the case.
Very interesting. So let's drill down for a minute. We talk about wolves and sheep getting slaughtered, right? And it's not something that we're here to glorify or revel in. This ultimately is a teaching podcast, but the best way to teach is to be examples. I'll let you lead on this, on what kind of scenario you want to illustrate. So the options are, maybe there's a illustration of a business owner that sold and had a non-compete, and then just through greed or opportunism or whatever, decided I'm going to compete against this guy anyways because I'm sitting on a pile of cash, and if he wants to litigate, let's litigate, but I have an opportunity to make money. What happened to that guy or lady that did that? And I guess maybe another scenario, if you want to talk about, it would be a scenario where an employee did sign a non-compete, went to work in this kind of metaphorical business across the street, and with that employee's knowledge and skills and customer contact base, did some substantial damage to his or her prior employer. In the real world, what happened? What kind of judgments are handed down?
Yeah, I think I said before, I've been both sides of these. I'm sometimes on the plaintiff side of non-competes cases. I'm sometimes on the defense side. I'll give you an example case where I was on the plaintiff side, representing an employer, suing former employee and the employee's new employer, by the way. The new employer can get sued on these as well. It's a claim called tortious interference with contract. I don't need to get into that right now, but when you hire an employee with a non-compete and the employee is going to be violating the non-compete by working for you, you need to know your business can be sued. In theory, sometimes I've seen claims against the individual owner at the business try to get sued too. That's a whole nother issue. When I was on the plaintiff side, so what happens quite often, like the anatomy of a non-compete case, right? Sometimes you'll get the cease and desist letter first. There's no requirement. They could just sue you. But sometimes you get the cease and desist letter. You must fire this employee within 3 days and let us know, or we're coming after you. It gets to the lawsuit stage. What often the plaintiff's attorney will do is go after what's called a temporary restraining order right at the beginning of the case. So everybody knows that there's a right to a jury trial. Everybody's familiar with that whole concept. And that's the same thing in non-compete cases. You are entitled to a jury trial to determine, did you breach the contract? What are the damages? All those things. But in certain situations in law, and a breach of a non-compete is one of them, if the plaintiff has an argument that what the defendants are doing is causing what's called irreparable harm to the plaintiff. Let me explain what that means. Irreparable harm means that what they're doing is going to create such damage to the employer that monetary damages will not fully compensate them. If monetary damages will fully compensate the plaintiff for the wrong the defendants have committed, that's the right to a jury trial. That's something a jury can deal with down the road and, okay, yeah, you're entitled to $100,000 or whatever it is. In non-compete cases, the argument is that there's irreparable harm. What is that? Loss of goodwill, loss of clients, loss of trade secret information sometimes comes into play. Things that aren't really easily quantifiable in terms of monetary damages, right? And so in those situations, and the non-compete is one of those, you're going to be facing a motion very quickly. You'll get sued, and you might be in front of a judge in a week. Or it could be in 3 days after you get served. It all depends on the court when it's scheduled. But you're talking potentially full briefing on a motion for a temporary restraining order where the plaintiff and its lawyer will argue to the court, Judge, you've got to issue this restraining order. And usually it's the defendant, the former employee can't work. If it's a non-compete, you cannot work for this employer during the pendency of this case. Or if it's just non-solicitation, not only that, they can't have any contact with our customers, fully enforcing that agreement during the pendency of a case. And obviously, for an employee who's trying to make a living and now suddenly they can't work, that's a problem, right? Now, after that, no matter how the temporary restraining order motion comes out, and I alluded to this earlier, Matt, a lot of times it depends on the judge you get sometimes whether that temporary restraining order is going to be granted. Like I already said, some judges are right to work judges. They're not going to fire the employee. Others will, if it's a situation where the former employee did something more than just violate the non-compete. They downloaded some information from the prior employer. that will even tip even some of the right to work judges to say, okay, you're nefarious, you've stolen information. But my point is, no matter how the restraining order motion comes out, plaintiff employer loses or wins, doesn't mean the case is over. So even if the plaintiff employer loses on that motion, that doesn't mean they still can't drag the defendants now through discovery, depositions. Now, if the plaintiff company is way bigger than the defense company, they can spend them into oblivion.
Bury them.
Bury them. Absolutely. Now, a lot of times the case is settled because, think about it, the way a temporary restraining order motion works is you have to establish to the court or convince the court of is that you got a reasonable likelihood of prevailing on your claims. Part of that in a non-compete case is that your non-compete is enforceable. So if you've got a judge in a ruling on a temporary restraining order motion saying, I don't think your non-compete's enforceable, so I'm denying your motion, that's a forewarning that maybe doesn't make a lot of sense to keep going forward with the case because the judge may ultimately down the road still dismiss the case on that basis. So it's quite often cases will settle either because of the TRO is lost for that reason. The plaintiff's employer doesn't want a final binding decision that our non-competes are not enforceable. Conversely, if they win and the defendant is out of work, they want to settle quick because they can't stomach it. But if the plaintiff employer is really ticked off, the employees violated this, brazenly set up shop right down the street, even though they got this clear non-compete, they can make their life hell for a year.
So let's dissect some of this because there's a lot of excellent, what I call adjudication insight. How is this adjudicated? TROs, temporary restraining orders. A lot of people are, if you watch some of the TV law shows, you can pick up all that stuff. Some of them may have been involved in it, had a TRO served on them, right? So we're here to help our small business listeners. And as you're explaining all this, I'm trying to overlay your comments on my client base and who I think might be listening, right? And the first thing going through my mind is in terms of staving off the wolves, right? Because you just described not one wolf, but a pack of wolves. That larger employer is unleashing a pack of wolves. What are these wolves? It's the litigation and the cost of litigation, number one. That might be the only wolf worth talking about because you told my small business owners, I said, no one ever wins in litigation, right? I mean, the lawyers are the lawyers, which is obviously not a true statement, but it's just one of those things. If you're going to litigate, you got to make darn sure that there's not a settlement option out there because you're going to be paying a lot of money. So they can bury in legal fee. But the other wolf is this TRO wolf, right? Because now you just hired this key employee, right? You had the big party and the onboarding, the training, everybody loves this. Wow, is this employee good? Where'd you get this employee? Right across the street. Yeah, my competitor. But now all of a sudden, if the TRO sticks, that employee can't work, right? So now not only are you facing the big corporate wolf with their war chest, now you got to deal with these employees not going to be very happy either, whether they're at fault or not, right? They're looking at you saying, listen, I don't care. I won't work. I get that, but you're still going to pay me. I'll stay at home, do whatever, but I still want to get paid, right? There's that whole issue, right? So before you respond, and I'm sure you got an ocean of responses on that, but this point has to be made. And you and I have talked about this earlier, Dan, through other business dealings or whatever. What is for that small employer that hires the big dog, if you will, that comes in, this person's going to transform our business, a wealth of knowledge and expertise. What does that prospective employer, what rights do they have to say, listen, before we hire you, we need to know, what are you dragging along with you? What ticking time bombs are in your briefcase in the form of a non-compete, non-solicitation, what confidential? So what rights do these small business owners have? Can they ask? They say, give me a copy of the agreement or what?
Yes, is the short answer generally. So as with everything in law, there's never a 100% black and white answer. But absolutely, I think it needs to be a required part of anybody's hiring practices to ask, do you have any kind of a non-compete, confidentiality agreement, non-solicitation agreement, those sorts of things. And yes, we'd like to see it before we hire you and to make sure that we can assess the legal risk from it. I've seen employment agreements with people you bring in where you have the employee certify, warrant in the agreement that they're not a party to one of those agreements. Or if they are, You can sometimes have indemnification provisions where the employee agrees to indemnify the employer, but that gets dicey, and those are generally probably not worth the paper they're written on. We won't get into that right now, but there's an actual employment indemnification statute in Minnesota that basically says employers need to indemnify employees if they get sued in connection with something they do in their employment. And so that comes into play on a non-compete. The employee gets sued on a non-compete, almost is going to turn to the new employer, you just hired me, but I need you to pay my attorney's fees now because I'm getting sued because I'm working for you. But anyway, going back to your question, yes, you can ask that. What I was going to say, I think I mentioned this to you the other day, Matt, there's a law in Minnesota right now that just went into effect recently. I think it was last summer. I think it was August 1st, that employers cannot inquire about salary or pay history. You can't ask an employee, or what are you making now? Or ask them what their pay requirements are. And if they happen to say, I'm making $80,000 a year here, and so I need 85, that's fine, but you can't ask that question. So when you ask me, can we ask for the agreements? Yes, it's a little dicey. If that agreement also has their pay, you could technically run afoul of that law. Maybe what you do is have them just give you the certain provisions that have the non-compete or something, or ask them just to black out.
Redact.
Yeah.
So, because the bottom line is, I have to believe that as a practicing attorney in this area, your recommendation for any client is get your hands on the full agreement, any and all employment agreements, non-compete, non-solicitation, confidentiality. We need to see them. We need to review them. If you're the business owner, it's worth a few hours of your law practitioner's time, your paid legal representative. It's because if it saves you $200,000 in a judgment and legal fees, it's got to be worth it all day long.
I tell clients an ounce of prevention is worth a pound of cure. It's true in law. It's true in medicine. Absolutely.
It is the never-ending challenge with small business owners, and I don't make this statement to demean them or say that they're naive or perpetually ignorant. It's tough to get small business owners to spend money on lawyers, accountants, tax preparers. Why? Because in their mind, I'd rather spend money on marketing. I'd rather spend it on the operations. Our producer here, Will, he wants as many of his technological toys as he can get his hands on. Yeah, but the bottom line is they don't know the consequences of these scenarios. That's why they're not spending the money. They don't understand. Yeah, business is about managing risk. It's about taking risks. It's a gamble every day, but there are certain risks that you do not want to roll the dice on. They're just catastrophic. So quickly, let's talk about a few of those scenarios. I want to hear some numbers. Like, what have you seen where judgments come in? And so in that scenario, we're talking about where the employee went across the street, he violated that non-compete. The evidence showed that there was serious damage to his former employer. Business dropped off. Maybe customers got wind that, hey, he's following this guy. I want this guy taking care of me. I don't care who he works for, but it's this guy or this woman, right? So what have you seen in terms of these judgments and all that?
Most of the cases I've been involved with haven't gotten into the millions of dollars of damages, but what you're hitting on is what we call hard damages. Your actual customers have been diverted.
Mm-hmm.
So that comes down to what's the reasonable expectation of the old employer that they would continue to do business with them. And sometimes that could be several years of revenues. And the actual measure of damages is profit, but whatever, that could be huge. It all depends on the nature of the case, the size of the clients, what type of product or service we're dealing with. But yeah, so it absolutely could get well into six figures. I'll admit, attorneys are expensive. This reminds me to go back to any questions of what are the ingredients of a non-compete. If you want a non-compete, have an attorney fee provision. Put in a provision about what are the remedies and things you can do if you sue and prevail, because the rule in the United States is you do not get your attorney's fees for breach of contract unless there is a clause in the contract saying you get your attorney's fees. So attorney's fees, depends on how long the case plays out, but all the way through a jury trial and a case like that with depositions, and that's the other issue. If you've got a lot of customers involved being diverted, that's a lot of depositions, possibly. And I mean, it's easy to get well into six figures of attorney's fees, even before trial. I guess the best way to answer your question, absolutely. I've seen these easily cases cost at least $500,000 plus when you figure it, attorney's fees, damages, all that sort of thing. But if you have a big wig employee that's got a $10 million book of business and they divert $10 million of that business in violation of non-compete, it's $10 million of damages. Not to mention that they may get the guy put on the sideline through a TRO In the meantime, you've got nobody doing that work, and you brought them in for nothing almost at that point.
And that is clearly a scenario where the wolves have moved in. It's full on disembowelment. That business is done. It's cooked.
If they're a small employer, absolutely.
Yeah. So getting back to our audience, just to hammer down the point one more time, why are we talking about non-competes? One of the major reasons is that there is a labor shortage in this country, and it goes from restaurants that are looking for servers and baristas. I see it among my contracting clients that are looking for just low-level manual laborers, crew leaders, project managers. It's also in the white-collar service industry, the software industry, engineering firms, architects. Finding talent, my own firm, I'm growing every year, but it's a challenge to find talent. And so the stakes get higher with something like this all the time. Why? Because it's not like we've got 20% unemployment out there where there's a whole fistful of these superstars that are looking for work. Like, the truth of it is, that superstar may be working for one of your competitors. And we're not advocating in any way that you go try to poach them. But if you're advertising and they see your advertisement on LinkedIn or Craigslist, you're not violating any rules. But you advertise, they answer. But once they answer, you're looking through that resume and you, oh my God, this person's perfect. They could be a perfectly engineered IED that you're going to trip over, and you're going to lose the bottom half of your right leg because of the agreements they signed. And especially if they're not upfront with you, right?
Yeah, the other thing I'll throw in there is it's, yes, non-competes, and it's also confidentiality agreements. But even without confidentiality provisions, there's a Trade Secret Act as well. And I don't want to get down to this too far, but this is another potential to become a slaughtered sheep. If they bring information with them, even if they don't have an agreement, there's just trade secret law. You can get the pantsuit off you for that employee. And it doesn't even matter. You can have an agreement with that employee and say, do not bring any information from your former employer. Do not bring it. Do not use it. If they do use it, guess what? You're still going to get sued, and you're still going to have liability because that was your employee and they stole the information and they're using it at your business. So that's just another example. Yeah.
Yeah. The other objective in this podcast is that we're not here to just scare the listeners into shutting down their big, dear God, why am I even doing this? Because there's a way through this. Obviously, it happens all the time that companies navigate this. It's a recommendation I frequently make when I bring on a specialist, a professional in the field. Hire a good tax accountant, hire a good corporate attorney that can help you navigate this stuff and lay the groundwork. They can investigate for you. It's not just about drafting agreement, but it's investigating. It's asking the right questions. Yeah. So I think that we have illuminated this issue to the nth degree and given the listeners a path whereby they can maybe not 100% avoid the wolves, but at least keep them taking every reasonable measure to keep them at bay, right? Ultimately, we live in a litigious society and there's no guarantees. I want to just one last topic on the non-competes. We don't have to spend a ton of time on this, but we're going to go in our scenario where we're talking about the former employer and the current employer and the employee that goes across the street, the same scenario. What about the situation where the former employer does not have a non-compete, does not have a non-solicitation or a confidentiality agreement? Now, I know that, as you alluded to earlier, I believe you refer to this as there's tort law protections out there of
Trade secrets,
conversion, all that fun stuff. I've had a front row seat on that. But this scenario is flipped where the wolves are now potentially at the door of the former employer because they didn't have these agreements. And so that employee left. What can that employee do within reason that could potentially cause damage to his former employer, but not have any liability to either him or his new employer? How is that former employer at risk because they didn't have these agreements?
That employee can effectively solicit all of the customers that employee worked with at the former employer. And let's face it, most companies, their relationship with the customers is through their employees. The customers, sometimes there's differences here, but usually the customers associate the business with their contact at the company, which is that salesperson or that employee that they deal with. That employee leaves, goes to your biggest competitor, and they can reach out and say, now I'm over here. We can service you. Oh, and I liked working with you when you were over at your old employer, and I'm going to come with you. Now that employee's got to be careful because I mentioned trade secret issues. That employee can't use or disclose any confidential information about the former employer's business at the new employer. So, for example, if that employee at the old employer knew what their pricing margin was, and then I'm going to use that to undercut them at the new employer, that could be dicey for that employee because that could be potentially trade secret, but it's really hard to prove trade secret violation. That's another reason why we have non-compete or non-solicitation agreements. So we don't have to get into that. We just know they reached out to the customer. We just know they solicited them. It doesn't matter if they used confidential information of ours. We don't know exactly what they told them. We just know they contacted them and they're trying to get them to leave us. So, I mean, that's pretty bad. The sales guy now is taking all of his or her former customers. If you have a salesperson that's 50% of your customer base and they can just take it all with them, that's a problem.
So one of the definitions that we laid out in the initial podcast of slaughtered sheep is what is the definition of being slaughtered, right? So the obvious ones are bankruptcy, total dissolution. But one of the definitions, one of the components is substantial loss of customer base. That is a form of being slaughtered. Make no mistake about it. Any of us sitting in this room woke up tomorrow and found out that all of our clients had left for one reason or another. It wouldn't be a good day. And that's a form of slaughter, and that's really where the tables are turned. And so once again, Dan Ballantine, the Larkin Hoffman attorney, is the lion in this scenario, right? That's who you are. And the lion is telling us in this situation, for all employers that are listening, can't think of a reason. And you're talking about key employees, right? You don't want to have it for every laborer out there, but for key employees, managers, whatever, there really is almost no excuse. You should have a non-compete. You should have a non-solicitation of confidentiality because you're absolutely playing with fire if you don't have it.
You've got the legal restriction on non-competes now, but the other competitive restrictions, absolutely. And the last thing I'll say, you had started asking Matt earlier about what are the ingredients, what has to go into, and I started talking about that. But the other thing I'll say about that, they have to be done correctly. And what I mean by that is it's black letter law in Minnesota that if you want to have any kind of competitive restriction with an employee, non-solicitation, confidentiality, non-compete, signed before July 1, 2023, I'm not going to go down the weeds too much in this, but you either have to give them that agreement with their your initial offer of employment. I want you to come work for me, but you're going to have to sign this agreement. Because in that case, Minnesota law says the job itself, it could be at-will employment, which I think your listeners probably know what at-will employment means. I mean, it means you can fire them after a week if you want. The job itself is a consideration for the non-compete or for the restrictive covenant. If they're already working for you, so any of you out there who have key employees, as Matt said, right now that do not have any of these competitive restrictions, you can't just have them sign it now because it won't be enforceable. The reason is that after they've started with you, you've got it. The Minnesota law says you have to give them something beyond continued employment, beyond just sign this or you're fired. The gist of the reasoning is the courts in this state have said it's like extortion. Once the employee's already quit another job in reliance on your offer, you don't make any mention of a non-compete or restrictive covenant. Now they've left their job. They've got a family to feed. Now they come to work for you. They worked for you a few weeks, and now you spring this agreement on them. What choice do they have? You're going to fire them if you don't sign it. So they got to give them something like, it could be a bonus, it could be a little bump in pay, it could be eligibility for some kind of commission, all kinds of things. And that's where a lawyer could help you too. But just make sure, you can't just give them the non-compete at that point. You got to make sure it's enforceable from that perspective.
So let me throw a clarifying scenario at you, just to put a finer point on this. If you have a scenario where an employer has an existing employment contract that expires, so might be a 6-month, 12-month employment contract where the renewal provision is based on mutual agreement. So I'll hire you for 12 months. Whether you work here on the 13th month will be solely based on whether or not you and I decide that this is a good fit and whether I want to keep you and you want to work here. Is that a significant enough event where I could sit down and say, okay, employee X, I've got the new 12-month employment contract. However, this time around, there's a confidentiality and non-solicitation that's a part of this. And if you're not willing to sign it, then our contract's terminated. So thank you for everything you did.
Yeah, generally, so you're talking about somebody that's already employed with you, does not have a non-compete restrictive covenant. Now you're saying, okay, look, I want you to sign a restrictive covenant. And what you're getting for it is you're getting this new agreement that tells you to get a year of employment. Yes, the short answer is if they're getting something beyond what they're already entitled to, and it's not just sign this or you're fired. It sounds like it's got to be a meaningful benefit. We don't get in the weeds too much on this, but you're at will versus for cause employment. Obviously, if you have an at will employee, I think everybody knows what that means. They can be fired for any reason. If there's a for cause provision, I'm going to give you a 1-year employment agreement. I can only fire you for certain reasons, or you get certain severance if I fire you without those reasons. That's a for cause agreement. Absolutely, that gives the employer real benefits beyond just sign this or you're fired. And that would support it too.
Okay. Interesting. That is a fine point, but I think most of my clients do have employment agreements with their key employees. So this conversation is relevant. Well, we definitely took a deep dive into this. As you and I alluded pre-show on this, we could have 17 podcasts on non-compete, non-solicitation. Now, would the listeners want to digest 17 podcasts on it? I don't know. I would. I'm a legal nerd. I love business law, but I think maybe circling back on this for updates, I think is good. And I've learned a lot on this. I thought I knew this topic. I've been involved in a lot of them, but yeah, hearing these graphic examples of what happens when these agreements are violated and when damage is done, wow, that's not fun at all.
We didn't say this at the beginning. I still run into clients that start off with, Dan, non-competes really aren't enforceable, right? And I think that's out there. And so all of you, that is not what you need to think. You need to assume a non-compete is enforceable. There may be arguments it's not, but you need to assume it will be. We didn't talk about this, Matt. Maybe you don't want to go into it, but there was an FTC rule basically banning non-competes nationwide. That rule was enjoined by, I think, a district court in Texas. It has not gone into effect. And now with the Trump administration, I don't think it will go into effect. It's going to be basically state by state in terms of whether these things are enforceable. And you just need to be sure. You can't assume a non-compete or restrictive covenant of any kind is not enforceable unless you get a legal opinion on it, really, at this point.
So, Dan, I enjoyed diving into that topic, and hopefully the listeners are taking notes. And at a minimum, when they get their attorney on the phone, they're going to be able to speak intelligently on this. But also, if somebody put a gun to my head and said, what's the one takeaway from this? The one takeaway for me is when you are getting ready to hire a key employee or manager, absolutely ask the question, do you have a non-compete agreement, a non-solicitation that you signed? Can we see a redacted copy that doesn't show your current pay or any of your benefits, but we need to see those provisions? I would say that if that's all anyone got out of this, that's worth its weight in gold.
Thank you.
Phenomenal stuff. I mentioned to you, Dan, before I invited you onto the show, how these shows typically play out. And when I first started doing this, my biggest fear was I get 15 minutes into this and we're out of subject matter and we're sitting around playing tiddlywinks and we don't quite know what to do. Will can attest that I have not run into that yet. It's typically the opposite. We start talking about a topic and we start running with it. And it's fascinating stuff.
I'm used to talking. Lawyers are paid by the word. But we're never accused of brevity.
I'm going to permanently remove that risk from you and the Slaughtered Sheep podcast that, running out of topics and words, that's permanently gone. We don't need to prepare for that, but we are running short on time. I do want to dig into, just maybe as a teaser for the next podcast, I want to dig into wage and hour a little bit. There's so many subsets of this: overtime, minimum wage, employee misclassification, 1099 versus W-2. Why don't you just pick a couple topics on this? I'll just let you speak on it, the experience you've had with your clients or otherwise. And then I think the next podcast, we want to pick this topic up and continue on.
Well, so maybe what I'll do is give some of the biggest mistakes, misunderstandings about these areas, and just that may be the teaser, so to speak. So you mentioned overtime, minimum wage. First of all, I think everybody knows what we're talking about, but just to be sure, we're talking about whether you have to pay an employee overtime if they work more than 40 hours a week. Under federal law, it's 48 hours a week under Minnesota law, but most employers are covered under federal law. And most people know there's exempt employees, meaning you don't have to pay them overtime. And then there's what we call non-exempt employees, that means they are subject to overtime. You do have to pay them overtime. The biggest misunderstanding there, they get this all the time, Dan, we don't have to worry about overtime because we pay this employee salary. That alone does not make the employee exempt from overtime. Yes, that is a component of why some employees are exempt. In the law, there's what they call the salary basis, but there's also a duties component. An example I give clients is if you hire somebody to flip burgers in your restaurant and wash dishes, you can pay them an $80,000 salary. Guess what? They're not going to be exempt from overtime. You got to keep the timesheet. If they work more than 40 hours a week, you still have to pay them time and a half after the 40 hours. So that's the biggest, and there's a lot more to wage an hour, but that's the biggest thing is paying a salary alone is not enough. And there's a lot to it. On the misclassification you mentioned, Matt, that's another teaser on that. Let me be clear what we're talking about. Independent contractors versus employees. I've had clients call me up and say, I want to treat this person as a 1099 employee. That is an oxymoron.
99 employee.
Yeah,
I love it.
employees are W-2, first of all. Contractors are 1099.
Oh my God.
But
That's good.
yeah, but there was a law in Minnesota passed within the last couple of years, basically huge fines now for misclassifying employees as independent contractors. And so the ante's got up now if you're going to play the game of, well, I don't want to pay payroll tax and I don't want to deal with all these issues, so I'm going to call this person an independent contractor. There's all kinds of tests and so forth about when you can call an individual an employee versus or a contractor. Maybe we don't get into all that right now, but that's something we can talk about. It's suffice to say this, it's very dicey and risky to take an individual that's working for you full time and call them an independent contractor. Very dicey. And I probably generally wouldn't recommend it, but that's another huge issue right now. And it can lead to all their problems of misclassifying, because think about it. You call them an independent contractor. They're not covered under your employment practice liability insurance. If that contractor you fire and says, I should have been an employee and you let me go because I'm black, for example. Now you don't have employment practice liability insurance because you've told your insurer they're a contractor. Unemployment, workers' comp. You don't have any of those things. That person gets injured on the job. And then by the contract, you really should have had me as an employee. Or that you don't have work comp set up now. There's all kinds of cascading effects if you misclassify an employee as a contractor. So that's another big issue. Anything else you think we should hit?
I think that this has been an excellent teaser, and the next podcast, we want to do a deep dive into this. These issues come up frequently amongst my client base. I'm a CPA. We get a lot of continuing ed on these issues. I guess maybe I'll just leave it with one last comment, and then definitely for Dan Ballantine part 2, we're going to pick up where we left off here, but you want to talk about an illustrative comment that shines light on how serious this is. So when I moved back to Minnesota, of course, I maintained my CPA license for 30 years. Minnesota State Board of Accountancy, you can call them up and verify it. So I did an in-person continuing ed class here in Minnesota, put on by the Minnesota Society of CPA. It was in Bloomington. They're at their headquarters. I don't know if that's still their headquarters or not, but
it is actually, I think.
So
Yep.
It was a construction accounting class, right? And it was put on by one of the premier construction accounting experts, and super nice guy, funny. And I was there to I have a lot of contracting clients. I'm a developer. I want to hear the latest and greatest on work in process and all that kind of stuff. Percentage of completion. The guy gets up in front of the crowd. We had a packed room, probably 30 accountants in there, and introduces himself. And he says, I'm going to throw a statistic at you, and I want everybody to write this down. He said, the number one reason that contractors go to prison in the United States is payroll taxes. Number one reason. It's not fraud. It's not theft. It's not assault. It's not embezzlement. And I remember thinking, okay, I get it. It's scary, but I'm here to learn about construction accounting. It was seared into my brain, just the way he delivered it. And over time, as I started to get into this consulting practice, I realized that what he was really saying was exactly what we were just talking about. It's employers classifying employees as independent contractors. Why? Just everything you said. They don't want to would have to withhold payroll taxes. They don't want to pay employer portion. They don't want to pay unemployment. They don't want to have to pay workers' comp. And the other reason that you could call it the qualitative issue is they don't want to inherit all of the rights that an employee has versus a contractor. And so that hit me right between the eyes when I heard that. And I was like, okay, it needs to be an issue that I need to be aware of.
Remember, the IRS got Capone. When the government doesn't get their money, that's usually when the other shoe drops. And that's in the classification of contractors or employees. That's why the government's making it such a big deal. They're not getting their money with the contractors.
Yeah. You'd rather owe the mob money than the government. I don't know if I go that far. Obviously, I'm just joking. But yeah, no, it's unbelievable impact that these wage and hour issues have. So the next podcast, Dan, we definitely want to dig into that. There's the rules. The IRS, I believe, has like a 13-point test where they determine whether or not you're an employee versus a contractor, but so do the states.
State has it too. I think the IRS used to have a 25-point test. It might have been reduced now. I have to check, but yeah. The biggest factor is control, the level that the company has of controlling the performance of the work that the individual, either employer or contractor, are doing. But yeah, there's all kinds of other components to the test too.
And we're going to dig into those components next podcast. I know you have a whole bunch of sheep that you need to save back at your Larkin Hoffman headquarters. I know ones you like.
Sometimes I slaughter sheep that were on the plaintiff side sometimes.
And that's okay. We forgive you. That's why we have you on the show. But
remember, when I'm on the plaintiff side, I'm protecting an employer, of course. And that sometimes could be a small business owner too, going after somebody on non-compete. They've spent the money to...
Sometimes you have to slaughter sheep to save sheep.
Correct.
That's what you're saying. Correct. We get it. We're all about sheep and the slaughter phenomena here. But Dan, listen, thank you very much. This has been fantastic. These insights, the detailed examples have been great, and we're definitely going to have you back on. We look forward to it.
Thanks so much for having me, Matt. And thanks to all those not to be slaughtered sheep that are listening in.
So before we leave, I'm going to sear the slaughtered sheep mantra into your brain, okay? And the mantra is that we shall become lions, not sheep.
I like it.